Hey, welcome to recent trends in premarital agreements, everybody. Before we begin, I have a couple of housekeeping announcements. You will receive your MCLE certificates shortly after the program. Please take a moment to complete the survey that is included with your certificate. Sponsors tonight, the Family Law section of Beverly Hills Bar Association is sponsored by White Zuckerman and Our Family Wizard. White Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practices services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing their daily responsibilities of raising children. Specialized features help co-parents organize routine, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. I would like to give a special shout out to our most recent program, Four Corners, the sequel to our Three Amigos program with a legendary 30-year history. For our new annual family law case update program, which went down on the 26th of January, we had judicial officers from 4 different district courts within LA County, and we had close to 200 attendees, which was a huge success. Announcement, Meet the Judges Night has been postponed to May 4th, 2022. We plan to have this event in person at Beverly Hills Montage Hotel. So keep an eye out for more updates in the email blast and make yourselves available for this date. Then we have 2 upcoming programs with our supervising judge, Judge Pham. First, on What's New in Department 2, which is happening next week on the 24th, where Judge Pham will share with both BHBA and LACBA members all the new updates in family law everyone is eager to learn about. Then again, we have her back on direct examination with Dan and Lauren on March 2nd, a look at Judge Pham personal history and path to the bench. Please keep an eye out for the email blast and don't forget to sign up. Now on to tonight's fabulous program. Erin, please take it away.
Thank you, Gina, so much. I'm thrilled to have the honor to introduce our esteemed panel this evening. First, we have the Honorable Elizabeth Scully. Judge Scully presides over a family law department at the Stanley Moss Courthouse, downtown Los Angeles. Prior to being appointed to the bench in December of 2020, Judge Scully was a certified family law specialist in private practice. While in private practice, her focus included mediation, collaboration, and minors counsel services in addition to traditional litigation. Judge Scully is an adjunct professor at UCLA School of Law, where she teaches courses in mediation and negotiation. Judge Scully is also co-authored and authored numerous books and articles on topics relating to dispute resolution. Our second person on our panel is Michelle Katz, who most of us know as Mickey Katz. And Mickey is also a certified family law specialist, and her focus in her practice is non-litigation conflict resolution services in family law matters. She does mediation as well as postnuptial and cohabitation agreements. Mickey has received numerous honors and accolades from her colleagues in recognition of her service and her extraordinary level of practice in mediation, including awards from the Los Angeles Family Law Mediation Lawyer of the Year in 2015 and in 2022. Mickey has a long history of involvement with the California Dispute Resolution Council the California State Bar's Committee on Alternative Dispute Resolution, and she has served on the California State Bar Family Law Section Executive Committee, as well as the Board of Governors for the Beverly Hills Bar Association. And Mickey is one of the founders of the Los Angeles Collaborative Family Law Association, at which she is a frequent speaker on the issues of mediation and the collaborative law process. Last, but certainly not least, we have Lauren Peckin. Lauren has practiced family law for 34 years, previously specializing in complex family law cases at Kolodny Law Group, formerly Kolodny and Antec. Lauren now has her own practice in which her focus is on non-litigation conflict resolution services, as well as the preparation of premarital and postmarital agreements. Lauren's service to our family law community spans decades. She is also a certified mediator by the American Academy of Matrimonial Lawyers. She has served in numerous roles on the family law section of the Beverly Hills Bar Association and the Los Angeles County Bar Association. And she has graciously served as the deposition officer for the Harriet Buhey Center for as long as I can remember. If you want more information about our fabulous panel or need to reach them, their information can be found in our materials for this evening. We anticipate the program will take approximately an hour. Any questions that you have, please post in the Q&A section, and the panel will try to get to all of them, if not most of them, after they are done enlightening us. And if it goes over, we will be able to adjust the credit everyone is receiving. And with that, without further ado, Lauren, take it away.
Thank you, Erin, for that wonderful introduction. So we're going to start with one prenuptial case that came down last year, the only published case that came down last year on prenuptial agreements, Knapp v. Ginsburg. And this case was not a divorce case. It was a probate litigation. The facts are interesting. Husband and wife negotiated a premarital agreement, part of which was to address wife's concerns that she have rights in a marital home if husband predeceased her. Wife retained an attorney to represent her in connection with the agreement. The attorney negotiated the agreement with an accountant, business manager who was husband's representative. Husband and wife signed this agreement in 2004. The attorney signed as wife's representative, and the CPA business manager signed as husband's representative. In the agreement, husband had agreed to buy a new residence and add wife's name to title as community property. Husband agreed to pay costs associated with the residence without right of reimbursement, which was about $30,000 a month. If wife outlived husband, she would receive the residence free and clear of any encumbrance, and his estate would pay the expenses for 3 years after his death. Upon wife's death, she had agreed to leave this residence to husband's children. The agreement had boilerplate recitals that reflected that both parties had been represented by and relied exclusively on independent counsel of their choosing, and paid for their attorney with their own funds in the negotiation of the agreement. The agreement also recited that it was reviewed by each of the parties and the respective attorneys or representatives. Husband later amended his trust to reflect the terms of the agreement. In 2007, so this is 3 years after the agreement was signed, the attorney who had represented wife on the agreement billed wife for reviewing the trust documents. That attorney had sent a letter to the CPA pointing out some discrepancies between the trust documents and the premarital agreement. Then 8 years later, in 2015, husband again amended the trust with the aid now of an estate planning lawyer. And in the amendment, the trust provided that husband would set aside a certain amount of money in a residence trust to cover the residence expenses to be administered by a different trustee. The attorney again represented the wife and wrote to the estate planning lawyer objecting to certain provisions of the agreement and proposed a postnuptial agreement, which was not done. Title to the residence was held as community property with a right of survivorship. Husband then passed away during marriage in 2016. Wife sold that marital residence for $10.2 million and used the proceeds to pay off approximately $3.9 million on the mortgage. She put the remaining proceeds into a trust she created and used some of the other proceeds to purchase and remodel a new home. Wife then filed a creditor's claim against husband's estate for $3.9 million, the amount of the mortgage she had paid off, which in her mind was consistent with the prenuptial agreement. The claim was not honored by husband's estate. And that's when the litigation started in this particular matter. Husband's children then filed suit to set aside husband's estate plan and the deed that had wife's name on there as community property under the claims, among other things, of undue influence. Wife filed suit against husband's estate for the $3.9 million mortgage payoff. As litigation went on in that case, wife became concerned about the enforceability of the agreement and got her attorney to agree to a tolling agreement on the statute of limitations for malpractice claims until April 30, 2019. Wife then settled with husband's heirs and agreed, among other things, to leave her new residence in trust for husband's children, limited her rights to access the principal of the monies she had put in trust, and agreed to pay her own fees. She then filed a malpractice action against the attorney, alleging husband had signed the agreement without waiving the right to counsel, making the agreement unenforceable. The attorney filed a motion for summary judgment, which was granted by the trial court on the basis of Civil Code 1588, because husband had ratified the premarital agreement several times in his trust and estate planning documents. The Court of Appeal then reversed. So one of the first takeaways from this case is the concept that a premarital agreement that is not enforceable under Family Code Section 1615 is void, not voidable, and accordingly cannot be ratified. When the court made this holding, the court said the plain language of 1615 states that a premarital agreement is not enforceable if the party against whom enforcement is sought did not execute the agreement voluntarily. The court went on and said, quote, "Not valid does not mean void. Yet, as plaintiff, who is the wife, points out, construing not to mean voidable would essentially render the separate waiver portion of the statute superfluous." And this is the court still quoted. "If 1615 were interpreted so that a party who is required and failed to sign a separate waiver could enforce a premarital agreement anyway, it would impermissibly read the separate waiver requirements out of the statute. We aim to avoid constructions that render portions of a statute superfluous." The second takeaway from this case is that the recitations of representation of counsel in a premarital agreement do not conclusively establish that a party was represented. So in this prenuptial agreement, the agreement had language attesting that each party had represented by an attorney, but it did not conclusively resolve the issue. And the court said whether the boilerplate language in the PMA stating that both parties were represented by counsel reflected reality remains an open question of fact that must be resolved by a fact finder. So this is important because the recitals in the prenup need to be true. And so in this particular agreement, although there was a recital stating that husband had been represented by an attorney, this has now become part of the triable issue of fact, which is why it was sent back down to the trial court. The third takeaway from this case is that parties cannot contravene statutes enacted for public policy reasons, such as 1615, by private agreement or subsequent conduct. And the court said in making that comment, they cited Civil Code 3513, which if you look in your civil code, it's part of those maxims of jurisprudence that we all learned about during our years of litigation, that we thought, when will we pull one of these out and cite them in a brief? Well, in this case, the court cited 3513, which says, anyone may waive the advantage of a law intended solely for his benefit, but a law established for a public reason cannot be contravened by private agreement. So in this case, the public policy of 1615 and the statutory mandates of 1615, one of them being that you either have independent counsel or you separately waive your right to independent counsel, took priority over people saying it but not acting it out in real life. And then the fourth takeaway from this case was injury for purposes of PMA occurs when a provision is not enforced. The attorney had argued that the wife's complaint was barred by the statute of limitations since the agreement was drafted 15 years ago. The Court of Appeal disagreed, noting that the wife did not sustain injury until husband's estate refused to honor her creditor's claim as provided for in the PMA. So the main takeaway, I think, of this case, even though the facts are very specific to what happened here, and this was not a traditional set aside of an agreement between parties who had signed a premarital agreement, is that the statutory mandates of 1615 is the roadmap of what you have to follow when you draft a premarital agreement. And they're very important. And if you don't follow the statutory mandates, that the agreement can be held to be void, even if you attempt, as many people have done in past years, to cure defects with an amendment after they get married or a ratification, that it could come back to haunt them because if the underlying mandates of 1615 aren't followed, the agreement can be held to be void, as I read this case. So Judge Scully, what were your thoughts or takeaways when you read this case?
Well, thank you so much for that beautiful and clear recitation. And part of our purpose today is not only to talk about some new approaches or new ways of thinking about preparing premarital agreements, but obviously to update everyone on the recent developments. And this really is the blockbuster published case that came down. And I think a lot of the holdings were surprising to a lot of people that do this kind of work. One of my takeaways has to do with that concept of ratification, because certainly, that it's customary in practice. I encountered frequently, the concept of a ratification either of the agreement itself or through other documents like estate planning documents, and a feeling like that was really belt and suspenders, or if things had unfolded in a way that, might have been cleaner because that's what life looks like, that if you could ratify that would really be a panacea or a cure-all. Apparently we can't count on ratifications. I had another couple of thoughts. When we talk a little bit later on about mediation of prenups, or about importing some concepts from collaborative into the preparation of prenups, a lot of why we're doing that and why that seems useful has to do with preparing these agreements in a way that is going to avoid disputes between the parties in the future, and preparing these in a way that supports and promotes the relationship that the parties have, and is an authentic reflection of their values. But let's remember, in this case, it wasn't the parties who had a problem with the premarital agreement. Neither party ever contended that the premarital agreement was invalid. And so, of course, we want to keep the parties in mind, but we have to have in the back of our minds at all times the specter of a challenge in the future. And that might not be the parties. It might be adult children, or somebody that wasn't involved in the process of creating the agreement. And so steps that we take to make the parties feel comfortable are all well and good and vitally important, but they also are not a panacea or may not protect against future challenges. And then my last thought, just a brief one, is that, think about how the cast of characters comes up when you're preparing these. And there may be a lot of social pressure by your client, who doesn't want you to second guess the other party's choices about who helps them and who advises them. We don't have a lot of control over professionals or representatives that the other party selects. And to the contrary, it may be very important to our client that we not appear to attack other advisors that the other client trusts. And so, practically speaking, you may find yourself in a position where there's really social pressure not to say, hey, wait a minute, this isn't going to be good enough. They need to have someone advising them and signing off who's a lawyer. So just be aware that the context in which this kind of issue may arise may be one where you have to think about how to explain this to your client, how to work with your client to present this problem to the other side in a way that doesn't appear to be second guessing them or trying to get them to not involve people that they trust in this process.
Thank you. Mickey, while this NAP case did not deal with spouses abort limitations or waivers, which is an area that we can't guarantee,
Right.
You're going to quickly tell us about what's on the horizon with the potential case that's been argued in front of the Court of Appeal last week.
Right. I just wanted to add, thank you, Judge Scully and Lauren, for that synopsis of this case and your thoughts, Judge Scully. That when I read this SNAP case, I thought to myself there, but for the grace of God, go I. I mean, I think that it's important to be aware of the kind of pressures that you're under when you're representing clients in the prenuptial agreement context. We have a hypo for this next part of our presentation. And in the hypo, imagine a situation where each partner has legal counsel to represent them in the negotiation and drafting of a prenuptial agreement. And the wealthy would-be groom pays the would-be bride's counsel's retainer directly to the would-be bride's counsel. On the way to the altar, and after finishing and signing the prenuptial agreement, the couple has a fight and calls off the wedding. And the groom asks the would-be bride's counsel for his money back. So when the counsel for the would-be bride refuses to refund the money, the husband goes to the state bar and complains. So my question is, what would you imagine the result to be? The lawyer had actually done the work, but the groom felt that since he was the payor, that he had some right to a refund of the funds since the wedding didn't take place. Whether or not his opinions were valid or not, there is in your materials 2 notices, one from an attorney to a client and another from the attorney for the client to the third-party payor. That makes it clear under the State Bar Rule 1.8.6, which is also in your materials, that just because the third party pays the fees of the other party's lawyer, there is no interference with the attorney-client relationship between the other party and his or her lawyer, and there is no interference with the lawyer's professional judgment about what is right for his or her client. So I would just wanted to point out the notices in the materials are notices that I've used. I used them only recently in a case where I was surprised when I got the credit card payment authorization form, and the name on the authorization form was not that of my client, but of her soon-to-be groom. So based on the Knapp case, I was very concerned that if absent the notices and the acknowledgements by the third party and the client, that there was no interference with the attorney-client relationship and that there was no interference with my professional judgment, that the agreement might be deemed to be void at the inception and therefore completely unenforceable. So I just told that out as a sort of cautionary tale.
Thank you, Mickey. Judge Scully, do you have anything you want to add on this particular issue?
Yeah, so again, this is a situation that arises very customarily. I mean, it's very typical, at least anecdotally, according to my experience, that a party who is the moneyed party or whose family is the one who is really eager to have the premarital agreement signed will pay the fees. And in fact, they're strongly incentivized to pay those fees to make sure that the other person is represented by competent legal counsel so that the agreement doesn't get set aside in the future. And I'm not sure how much this ethical issue of having another person pay is always on our radar screen, or certainly you think about, okay, I don't want there to be any ambiguity about whose interests I might be representing. But if that was your only concern, maybe you just say, all right, well, if he's going to pay your fees or she's going to pay your fees, they should gift you the money so that the retainer actually comes from you. But in light of this scenario and thinking about it a little more critically based on the notices and the information that Mickey has provided, I wonder if that solution isn't really a little too form over substance, and that if you want to be fully protected, both against the implication that somebody else might have been influencing your work as the consulting attorney, but also against any state bar repercussions, then the better practice would be to probably do that and have these notices. And my other thought, just in terms of practicalities, would be, think about how your office works and who is the person that is usually in charge of collecting payments and credit cards. And sometimes it's us. For a time, I was a one-woman shop, so I would have been the one doing that. But if you have staff or even an accounting department who's in charge of taking the credit card information, you need to make sure to train your staff and alert them to that issue. Because if your client just says, I'll call with a credit card number, and you say to the accounting person or the legal assistant, okay, someone's going to call you with the credit card number, you may not ever realize that the name on the card is different, and you need to make sure that if it is, that your staff is alerting you to that issue, because it's actually very significant, both in terms of enforceability and obviously in terms of professional responsibility.
Those are very good points. Before we leave this particular issue, we just want to alert everyone, because we all sort of wait in the aisles anxiously about what case will ever come down on the issue of unconscionability of a spousal support limitation in a premarital agreement. So we are aware from fellow colleagues that last week, a case that has been pending for a while was argued before the Court of Appeal, where a spousal support limitation was at issue along with a prevailing party provision, which many of us use in many of our agreements. And it'll be interesting to see what the Court of Appeal does on the issue of unconscionability, how they define it, whether it will be pertinent to that couple and their marital standard of lifestyle, or whether it will be more of a broad brushstroke of how to define unconscionability more than it's been defined in the past, which has been very little, as a footnote in the Factor case. So we'll all anxiously await for that case if it gets published. So the next topic we are going to talk about is mediating prenuptial agreements, and the issues that come with this. Because when we were talking about it and preparing for this panel, there's some really interesting issues that arise when you think about mediating a premarital agreement. Whether you're the mediator who's being asked to mediate agreement, or whether you're a consulting lawyer for one of the parties in a mediated premarital agreement. If you're the mediator, what's your role? Should you draft the agreement? Should you just be involved in the negotiating between the parties without outside counsel, so that the parties are participating and have a stake in what's going on in the negotiation? Does it matter strategically whether you draft the agreement or not as the mediator? And if the mediator drafts it, do you want consulting counsel to sign off of it, versus will you be a mediator who handles a mediated prenup with two people that choose not to have counsel? I'm not aware of any requirement that says you have to have counsel, just that you knowingly sign a waiver if you're not going to have counsel. And then I think one of the more important issues strategically, if you have a mediated prenup, is the mediation confidentiality, because that is something that we deal with a lot in our divorces. We have the evidence code sections in your material. Judge Scully, talk to us about mediation confidentiality and strategically how it could impact the negotiation and preparation of a premarital agreement.
Thank you. Yeah, and just as a premise, when thinking about, is it advisable? Is it a good idea? Should we really be actively exploring increasing use of mediation in the context of premarital agreements? There are a lot of things that are characteristic about mediation that might be really constructive and positive in the context of a premarital agreement. The philosophy of mediation about self-determination, about party control, its emphasis on relationship building, its emphasis on communication skills and mutual acknowledgement. If something is mediated like this at the beginning of the relationship, then the parties have then a track record or a concrete example of how they tackled some really thorny, really difficult issues in a positive way and we're able to work through them. And maybe that will be an important basis for their confidence in their own problem solving skills as spouses. And also in terms of compliance and feeling comfortable with agreements, there's a lot of research that if people feel very invested in an agreement or helped construct it, then they'll feel more comfortable with it and maybe you won't have compliance issues. So lots of reasons to explore the possibility of mediation in this context. But it's really crucial. Another fundamental aspect of mediation is this concept of mediation confidentiality. It's a very vital aspect, a fundamental value and characteristic of mediation. And that, is for lots of reasons, but just generally speaking, because there's a sense that if people are going to communicate freely and honestly, they need to have a sense of safety about when and how those communications might be used, that if people understand that their communications are confidential, maybe that encourages them to really sincerely and authentically identify their underlying needs and concerns, and that will be important in constructing a workable agreement. And also that it implicates mediator neutrality, in that if there's a possibility that the mediator might ever testify in favor of one party or against a party, or might be taking positions or publicly or in a legal context, then maybe that has neutrality implications, and the neutrality of the mediator is also crucial. And even though we all kind of know that mediation is confidential, and we kind of know that there's that chunk of the evidence code that talks about mediation, it really bears looking into carefully and reviewing those very crucial sections of the evidence code. It starts with section 1115. Those sections are in your materials. You don't have to follow along or anything now, but just know that those are there so you don't have to hunt for them in the future. But some of them are counterintuitive. It is a nuanced California mediation confidentiality. It's a lot more complicated than mediation is confidential and what happens in mediation stays in mediation. So take the time to really go through those, but I'm just gonna, so with the broadest brush, accentuate some of the highlights of mediation confidentiality, so that that's context for our conversation about how it might impact preparation of premarital agreements. You hear people refer in the vernacular to mediation privilege. Technically, it isn't a privilege. Privileges can be waived either intentionally or inadvertently through disclosure. They could be waived by just the holder. Mediation confidentiality in California really is not a privilege. It is an evidentiary bar. That's the kind of confidentiality that we're talking about. Okay. So mediation is defined very broadly in the evidence code, and it includes, for example, consulting someone about the possibility of participating in mediation. And where the evidentiary bar, that is mediation confidentiality in California, applies, it applies strictly and absolutely, really without exception. There are a lot of California Supreme Court cases saying, yeah, we get that it's kind of unfair, but nope, it applies strictly and it applies here. Or, gosh, yeah, we see how maybe some other public policies like fairness or disclosure might be implicated by the fact, but nope, mediation confidentiality applies strictly. But also, let's remember, there are lots of situations in which it does not apply. It applies to California state cases. It does not apply in criminal cases, even if they're in California. It does not apply in federal cases. it does not apply in non-California litigation. So, for example, let's think about having a venue clause in your premarital agreement that where you bargain for where litigation is going to take place, if any does in the future, over the validity of this prenup. We typically have that because we want to make sure, listen, hey, California prenup law is really technical and we're doing section 1615 and we're not licensed to practice in other jurisdictions. But it could be crucial because if there is future litigation over validity that doesn't take place in the state of California, maybe there's a question then about whether confidentiality applies if that prenup was mediated. The mediation confidentiality governs, communications. It governs documents prepared for the mediation. You can't sort of wheel bankers' boxes of bank statements into the mediation room and then claim that they're somehow covered. You can't, insulate evidence that's otherwise admissible or discoverable by kind of loosely involving it in the mediation. But when you have a mediated agreement that is signed by everybody and that is agreed to by everybody that has certain magic words in it, that agreement is admissible. So we're going to touch on thinking of strategically about mediation confidentiality and anticipating this issue if we were to mediate a prenup, and what information we might want to be inadmissible and covered, what information we might really want to be admissible in the future. All right. If there's going to be any disclosure, then the mediator also has to sign off. All the parties, every single participant in the mediation would have to consent to disclosure of these materials, and newsflash, no mediator is likely to ever agree to that. Okay. And then there are provisions that say disclosure of information that should have been covered by mediation confidentiality can be grounds for a mistrial or a new hearing. There can be fees awarded to mediators for unsuccessful subpoenas if you inappropriately try to rope them into litigation. And then I always want to point out to everyone that 10-day rule that's in Evidence Code section 1125A5. And that statute governs when a mediation ends for confidentiality purposes. And I feel like it is a surprise to a lot of us and not commonly known that under the Evidence Code, if for 10 calendar days there is no communication between the mediator and any of the parties to the mediation relating to the dispute, the mediation has ended for confidentiality purposes. And I think that this was written with a particular context in mind, maybe a one-day mediation, a sort of one and done mediation. That's not what our family law mediations ever look like. And it's unlikely to be what a mediated prenup conversation would look like. How often do you schedule another meeting, or you sort of leave off and everyone has homework and things that they're going to talk to their consulting attorney about, and you leave it up to the parties to get back in touch and schedule another session, and more than 10 days have elapsed? Technically, then, has it ended? And it's really important to contract around that if you want to at the onset of your mediation, and just make it really clear, listen, we don't want this 10-day rule because we understand that it's in practically every family law mediation I can ever think of, there are 10-day gaps without any communication. We want to contract specifically that, mediation isn't done until there's a specific notice with specific language or something like that, so that there's no ambiguity about that. Okay, so that's an overview, some things to think about there. And before I talk about then what the implications might be if we mediated a prenup and the confidentiality applied, Lauren or Mickey, do you have any questions or points or anything that you wanted to say at this point?
Well, the one thing I just want to remind everyone is when Evidence Code 1129 came down, I think it was in 2020, and that was as a result of this mediation confidentiality, and it came as a result of a case where an attorney was reported to the state bar because of his actions during a mediation, and there was a great debate in the mediation community about making some exceptions to the mediation confidentiality. After that whole debate, the legislature amended and codified 1129 with a mediation disclosure notification and acknowledgement. Copy of that notice is in your material. And the point is that when you're the mediator, although we're used to doing these notices when we do dissolution matters, we just have to remember that if you're going to mediate a prenuptial agreement, I think that you have to do one of these notices and the client has to sign it, and if they have a consulting lawyer. And what it does is it tells the client that while everything you're doing in this mediation is confidential and the communications and your drafts of agreements and so forth, that there are two exceptions, and it does not limit your attorney's potential liability to you for potential malpractice or preventing you from reporting any professional misconduct by your attorney to the state bar or cooperating with any disciplinary action. So just remember, if you're going to mediate a prenuptial agreement, to make sure if you have consulting lawyers for the clients, that the parties and attorneys sign the mediation disclosure notification that's now required under Evidence Code 1129. So if you could, before Mickey talks about how to remedy how we deal with this mediation confidentiality issue, Judge Scully, talk to us about the practical application in the real world. What does it mean if you have a mediated prenup? And as a former litigator, when we used to draft prenups, we think about what do we need to do to make sure our agreement is valid and enforceable years from now. We keep our drafts, we keep all the letters and correspondence, we keep notes of our conversations with the client, we wrote CYA letters, whatever it was. What's the practical application of this mediation confidentiality in the real world now?
Right. So again, as I mentioned at the beginning, although we want to be doing this in a way that is, or using resolution processes that really promote and support, these beautiful relationships that our clients are embarking on at a moment that's joyful, right, and positive, although sometimes it gets, we lose track of that. We want to make sure that we are anticipating the possibility of a future dispute or future litigation over premarital agreements. We all know it's a quote unquote dangerous area, that the malpractice risk is high, that there is, a risk that these are going to be set aside. And so we need to think about, if we were involved in a premarital agreement that got challenged and we were involved in litigation about the validity of that premarital agreement, what would we want on our exhibit list, right? What kind of information would we want the judicial officer to know in order to convince them that, yes, it was knowing, it was voluntary, it wasn't rushed, it complied with 1615. Well, all the drafts that went back and forth, the letters between counsel where people said, no, this isn't protective enough, or this interest that the client has isn't being addressed, or we want this. Yes, absolutely, we'll make that accommodation to show that something was really bargained for, to show that there were lots of communications about it. Maybe there's correspondence about whether or not it needs to be translated or language issues. Maybe there's correspondence about a draft financial disclosure statement that may have been prepared, and somebody else is asking financial questions that then get addressed, or asking for follow-up documentation that then gets addressed, right? All of those kinds of documents would be wonderful evidence that the agreement is valid and should be upheld. But think about that. If you've mediated the premarital agreement, then the discussions with the mediator where clients gave informed consent and recognized what the law would provide in the absence of an agreement, but they're agreeing to do this, none of that comes in. All of the correspondence between counsel or the red line drafts showing the extent, how heavily this agreement may have been negotiated, maybe none of that comes in. Draft financials, not the documents that are actually attached to the agreement, but backup, cover letters, requests, or financial disclosures that are made that may not make it into the actual document, but tend to show that the disclosures were full and fair, and that there was transparency. Maybe none of that comes in, right? So you see, again, if you're not very strategic and very careful about this mediation confidentiality issue, you may happy process your client out of the ability to defend against a challenge later. And I think that there is a way to resolve it. I think there is a workaround that might allow us to explore mediation as a possibility in this context. And Mickey's going to tell us a little bit about what that solution might look like.
So I've been dying to jump in here.
I know.
One of the things that I had thought of when we were preparing the program is that just as we keep a timesheet for the work we do during the day, one could develop a form that's kind of like a timesheet and have one in every prenuptial agreement file that details the dates and the activities that you as the mediator were privy to, so that you could have a record of the drafts that were circulated, and you could have a record of numerous emails between counsel and the mediator, or the clients and counsel and the mediator. You could have basically a log of activity of what went into the preparation of the prenuptial agreement, so that later on, anyone who wanted to argue that there was duress or that it was involuntary would be hard pressed to win that argument if there were sufficient detail about the work that went into it. So that was something that I had wanted to say. And getting back to I'm sorry to jump around, but getting back to the evidence code section that provides a 10-day termination of mediation if there's been no contact. I have in my mediation retainer agreement that the evidence code says that the mediation terminates if there's no contact between the parties and the mediator for a period of 10 days. And then I go on to say that it is typical in my retainer agreement, it's typical that in a mediation, there may be no contact for weeks between the parties and the mediator because of information gathering requirements. People go on vacation. We don't, as in commercial mediation, typically in family law mediation, we don't gather the parties together, lock the door, and tell them they can't leave until they have a deal. I mean, we bite things up into little bit of, into little, manageable chunks, and then they're free to go. So I just wanted to suggest that my retainer agreement has never been tested. I can't guarantee that it will work, but I've never had a question about it. But I think you can guard against that involuntary termination ahead of time if you're careful.
Thank you, Mickey. So to bring this particular issue just to closure before we go on to the last topic, I think the important point here is if you're going to have a mediated prenuptial agreement, and if you're one of the attorneys representing one of the parties, and you know that this mediation confidentiality is going to cover the process of the negotiation and drafting until you get to the final document, that it suits you well to have a more detailed resuscitation in the agreement of how many drafts were done, what financial documents were exchanged until you get to the final contract. Because at the end of the day, if you have a mediated agreement, as Judge Scully said, all the drafts you did, all the red lines, all the conversations back and forth are potentially going to be, not potentially, I guess, are going to be barred from admissibility because of the mediation confidentiality. So
Yeah.
to get to our last, go ahead.
Oh, no, I was just going to say, so the answer to this, or the remedy to this is, just to build on what Mickey and Lauren were saying, the agreement itself is your tool. The agreement itself is your remedy, because we know from having reviewed the evidence code that the thing that is admissible, the thing that takes information out of that evidentiary bar of confidentiality is if it's included in the agreement itself. Right. So I think there's a question in the chat that I think is referring to the point that Mickey was making about keeping a log or keeping notes so that that's documented. The log itself is inadmissible, but the purpose of that would be so that you can very easily draft a provision to be included in the agreement that includes all that information. I think the very fact that 15 drafts of an agreement were exchanged is a helpful fact, that you might want to say they started talking about it on this day and we had this many mediation sessions on this date. Each session lasted this many hours. But it's not to keep notes so that the mediator can keep track in the abstract. It's that is going to make it possible for you to include that information in the agreement very specifically without having to scrabble to reconstruct that later, because I'm not sure you ever could if you didn't do it intentionally as you move forward.
Exactly right. And if you're not going to have a mediated prenuptial agreement, then most of us keep our working files with the drafts and the communications and the notes and just hold it, for until you're no longer practicing. If you haven't been completely, frightened by this concept of mediated prenups, we don't lose hope, because there's another way to still do prenuptial agreements, which is small c collaborative approach to prenups, which we're going to talk about. And I just want to say that the old model of how we used to do prenuptial agreements when I first started practicing law in the dark ages was senior partner would come to me and say, here are the terms for a prenuptial agreement for our client, draft this. And I'd ask, well, am I supposed to talk to the client? No, this is what you're drafting. And I would draft it, and I would have very little dialogue with the client. I wasn't even sure the client had read it. The draft would then be given to the client, who would give the draft to his beloved fiance. And then the negotiations thereafter were between the attorneys. And I always wondered as a young associate, how much did the parties even know what was going on in the dialogue until they signed the agreement on the day they signed it? So throughout the years, and I think it is reflective in the case law over the years and the way 1615 now reads, in a more protective manner for parties, we've come to approach prenuptial agreements in a very different way than when I first started practicing law. So Mickey, talk to us about small c, the collaborative approach to negotiating and drafting premarital agreements that many of us do today.
Well, first, perhaps I should reference what collaborative law is with a capital C, and that's it's a process and a consensual dispute resolution process, as everyone knows, that in which the parties are represented by counsel, and the work of the negotiation is done in four-way meetings. And in the formal collaborative process, there is a team of collaborative professionals, including a mental health professional who coaches the parties, and in the case of divorce, often a child custody specialist who helps the parties with the child custody plan, and as well as a financial, did I say that? A financial professional who's involved. So in the preparation of prenups, also the key element of the collaborative with a capital C is there's a disqualification piece that the parties and their attorneys sign ahead of time, that they won't go to court to resolve the issues at hand. So this prenuptial agreement context is like before there's any divorce or any chance for litigation, hopefully. I mean, one that's sort of like not in the, that's not part of the, I mean, prenuptial agreements, I think we've made everybody nervous enough. We don't have to add litigation to the picture. But there are a lot of aspects of the collaborative process that seem to be really well suited to the negotiation of prenuptial agreements. For one thing, you have couples who are embarking on a relationship, so they don't have a history of bad communication or miscommunication. And so the professionals involved, the attorneys, can really help them learn or model communication skills for resolving issues that come up around money and the kinds of issues that newlyweds or about to be newlyweds have to think about. In some cases, a mental health professional may be a big help in helping the parties to come to an agreement. You may have a case or cases where the couple that's getting married, the individuals are of different culture or different backgrounds, and maybe one party wants the prenuptial agreement, or one party's family is insisting on a prenuptial agreement, and the other party comes to the process kind of kicking and screaming. So in that case, a mental health professional might be very, very useful. I am always amazed when I start a case, a new case, a prenuptial case, how many times I hear that my client has never had a conversation with her soon-to-be spouse about money. And it has always seemed to me to be, you know, like the primary area, or one of the main areas for disputes to arise. So, so any resources that are available to help people have these difficult conversations are you know, can benefit the process and benefit the negotiations. And then typically now when I do a prenuptial agreement, the work of the agreeing process, or the process of agreeing, is done in a four-way conversation. If not in the same room, at least through Zoom or through email, so that the elements of collaborative are there. And that's why we think of it as collaborative with a small c.
Right. And then I just want to add that many times, if we have time permits, we prepare a term sheet without doing the whole agreement yet and get a meeting of the minds of the parties on the substantive terms. And it really is a conversation that the parties are forced to talk about these issues. And I think we're seeing more and more young people that do want to contract out of California community property law. And so they like this collaborative approach on how to deal with a prenuptial agreement. So Judge Scully, you're going to bring it home here on your closing thoughts on the collaborative approach to how we do prenuptial agreements today.
Right. Thank you for that. And the closing really is relevant to both these concepts of mediation and collaborative. And just to echo what Lauren said, I also remember the days when the giant form boilerplate prenup was thonked down onto the desk of the other person or handed to the other party. Complete legalese, hundreds of pages long, so intimidating. And I have, remember lots of situations in where it felt terrible to me to be involved in a process like that. I really just felt like I was helping entrench some power imbalance in a really ugly way. That was not, that was not why I went to law school. That was not the kind of helping people that I had in mind. And how destructive it was to the relationships, and really kind of heartbreaking, because it's supposed to be a moment of hope and joy and, thinking about an us, and suddenly everyone reverts to, having to think about a me. And I notice that when a premarital agreement is done this traditional way without importing any of these new kinds of concepts, the bitterness and the resentment really colors the relationship. And the first thing the potential new client comes in and tells you in the divorce consultation is how miserable and humiliating their experience was in the prenup, right? It doesn't go away. So again, real reasons why these beautiful processes that have developed to really be more relationship centric, to really be more empowering to people, are so important to consider. And at the same time, then, when you're doing this, when you're importing these new concepts, you have to remember this confidentiality. Confidentiality is also a component of collaborative. It has some different sources, but often it's analogous. So I think the confidentiality concerns would apply generally, or aren't so different when you're thinking about importing collaborative concepts. But you're going to have to make sure then that you remember that the premarital agreement itself is going to be your tool, and that all of the facts, thinking forward to in the future, if this were challenged, what are all the facts that we would be trying to establish through the documents on our exhibit list? And how can we work those facts into the language of the agreement itself? And it means that a lot of your work with the couples as a mediator or as an attorney operating in this mode is going to be not only negotiation over the substantive terms, but a lot of time, a lot of negotiation, and a lot of discussion over the language of that agreement itself. But I think that, it's that being transparent with people about the need to negotiate the language in that way is a good way to get their informed consent to this whole process, and to make sure that they truly understand what kinds of things they're giving up and what kinds of things they're getting by participating in a less traditional process like mediation or collaborative.
Thank you, Judge Scully. So do we have any questions, Erin? And
Yes, so first, several people have pointed out that there were a few things missing in the materials provided. So if everyone can go into the chat section of your Zoom, at 7:08, we posted the complete materials. If for any reason someone doesn't get those, please feel free to email me at egray@enensteinlaw.com and I'll be happy to forward them to you. And if the panel doesn't mind, we just have a few questions. First one, from Barbara Hammers, is why not have the language in Mickey's letter in the retainer agreement so you're covered in the event someone else pays the bill?
Let me respond. We had talked about that. And if you had the language in the only in the retainer agreement with the client, the only person acknowledging that there was no interference with the attorney-client relationship and that the attorney used their best professional judgment, the only person doing the acknowledging would be the client. And you've got to get the acknowledgement of the third party who pays the bill, who says, I am paying your bill, and nevertheless, I understand that I do not have an attorney-client relationship with you, Mickey attorney, and that I understand that you're going to exercise independent legal judgment for the benefit of your client and not for my benefit. So I think the retainer agreement, you can also put it in the prenuptial agreement that the fees were paid by XYZ. But I think without, just after the Knapp case, I think we're all, at least the three of us, were sufficiently concerned that that it might be a bigger problem than we anticipated, because I didn't start using this third-party consent forms until after Lauren and Judge Scully and I went through the Knapp case in detail. And then it became, really important.
right, and let me just say one thing. Lots of times when we do our retainer agreement, we don't know who's paying the fees. We assume it's the client.
Yeah.
And then even these forms that Mickey has put in the material, they're relatively new. I've only been seeing these for the last 6 months. I mean, I know the rule of professional conduct has been there, but we've been made more aware of it because of a particular incident that happened with one of our colleagues. And while we had language in the prenup, so I think Mickey's right. While you can put language to the client in the retainer, you still have to have the third party notice as a separate document signed by the person paying the fees.
Right.
Okay, thank you both. One more question. Under Knapp, what is your opinion as to whether a non-California premarital agreement that does not contain the specific language of Family Code 1615 is void? I believe the question is predicated upon enforcement in California.
Okay, say that. So
under Knapp,
yeah.
Does that mean that any non-California premarital agreement that does not include the specific Family Code 1615 language, is that void? So is a Knapp, was the agreement void because it was drafted and executed in California as well as enforced in California? What would happen if if there was not a controlling law provision in a prenup that was perhaps executed or drafted in New York, but at the time of divorce or dissolution, the family was in California. California had jurisdiction. One person filed a motion to set aside the prenup. And we're litigating in California, would Family Code 1615 still control?
Well, let me just respond, and then Judge Scully, you can weigh in. I mean, my personal opinion is no. The choice of law, you would look to the choice of law of where the agreement was drafted. So if it's a New York premarital agreement drafted under New York law, and the parties end up moving to California and get divorced in California, that a California court, if there's a choice of law provision saying this agreement is done under New York law, is going to look to New York law. So 1615 will not apply. Now, the reverse of that is if you have a California agreement done under 1615 and you haven't done all your mandatory requirements, a couple moves out of California and let's say moves to New York and files for divorce there, I believe a New York court will look to California law requirements as to the validity and enforceability of that agreement. And then I think 1615 could apply. But Judge Scully, what do you think?
I haven't researched it separately. That would be my gut reaction. So nobody cite that back to me in Department 27 without a memorandum of points and authorities. But that it's a function of not where the agreement was drafted, but of what law is applying to the enforcement action, either because of the venue of the enforcement action or because of choice of law contracting in the agreement itself.
Right.
That would be that's my gut reaction.
So the short answer to that question would be no, 1615 would not apply for a New York or out-of-state prenup.
Unless there was no, the short answer is it depends.
Well, it depends on the choice of law, but if the choice of law was a state other than California, 1615 would not apply.
Right. And is anyone willing to disclose the name of the case that's currently was argued last week regarding the unconscionability of the spousal support? Someone wants to know the name of the case.
I mean, it's public. I don't know. Judge Scully, can we disclose it? I don't.
Oh, yeah. Isn't it Marriage of Zucker, Zucker?
Correct.
I think that's a matter of public record.
Right.
Well, Lauren and I both worked on the Pendleton case back in the day.
Oh.
Okay, so for anyone who I think that's it. Hold on. Okay, Jeremy would like to know, does mediating a prenup without separate attorneys make sense under Family Code 1615 C1? Wouldn't you still want each party to have independent counsel for the final sign-off, just like we would if parties negotiated a judgment in mediation and, the mediator says, well, bring it to separate attorney, please to sign off on? Would the same apply to a mediated prenuptial agreement?
I'd like to take that. I think, and I do lots of mediation and divorce, I'm much less inclined to insist that parties going through a dissolution of marriage action have counsel than I would be in the prenuptial agreement context. In this context, I would say I would be loath to mediate an agreement without the parties having counsel. I just don't think a waiver in that situation would be enough.
I agree.
That would just be my feeling. But I wanted to add something before we wind up, is that I love doing prenuptial agreements. And I realize there's sort of a tenor to this conversation, like, oh my God, you have to worry about this and you have to worry about that and you have to think of this and you don't know who's going to want to litigate later on, and it might not even be your client. It could be their kids. And I mean, this parade of horribles. I just hope that we haven't discouraged anybody from doing prenuptial agreements, because they're a lot of fun. I mean, first of all, your clients are happy people, mostly. They're really delighted to see you. And besides that, your relationship with them is pretty short term, given, compared to a dissolution of marriage case. And so you don't have time to fall out of love with your client, you know, I mean, so they're really a lot of fun. And because of the risk involved, you know, I hate to say it, but you can charge a nice, healthy fee and they're happy to pay it. But so I just hope we haven't scared too many people away, because they're really fun. I love them.
Yes, we have
Especially-
fun doing them.
Especially when you have a friend, a colleague on the other side who you respect and you enjoy working with, and who's kind of like part of your community. It's really great fun, I think. So I just wanted to say that.
Well, thank you so much. And Lauren and Judge Scully, do you have anything you'd like to add before we conclude?
No, thank
No,
you
I'm-
for including us. And
Yeah, thank you for inviting us to speak.
everyone. Thank you, everyone, for your attention.
Yes.
Well, thank you so much to our amazing panel. I feel like I learned a lot, and it was wonderful to see everyone. And if anyone has any questions afterwards, please feel free to email me. Thanks so much, and we will see you next week.
Thank you.
Thank you all. Bye.